Parles-tu français? Hablas español? Parli italiano? If you've used Babbel, you would. Babbel's conversation-based techniques teaches you useful words and phrases to get you speaking quickly about the things you actually talk about in the real world. With lessons handcrafted by over 200 language experts and voiced by real native speakers, Babbel is like having a private tutor in your pocket. Start speaking with Babbel today. Get up to 55% off your Babbel subscription right now at babbel.com/Wondery. Spelled BABBEL.com/Wondery. Rules and restrictions may apply.
The important thing to know is that an administrative warrant does not authorize ICE to arrest anyone in a non-public space.
Right. So then, knowing that ICE was just there to ambush a defendant in her courtroom, Judge Dugan and another judge went to get the chief judge to figure out what the hell they were supposed to do. Welcome to Law and Chaos. This week, it's chaos on every front. Also, lawsuits. Trump is getting sued by all the blue states. He's getting sued by the American Bar Association. He's getting sued by immigrants. And so far, he's mostly losing. Is that why he's trying to poison the milk supply? We've got a lot to cover, so let's get after it. Hey guys, I'm Liz Ty, and with me, as always, is Andrew Torres. Andrew, how are you?
Hey Liz, I'm doing great. How are you?
I mean, like, my space bar is broken, so it's made typing a little bit, like, I'm like, my thumb really hurts.
I mean, fortunately,
anyway, but other than that,
you don't have to write for a living or anything like that.
Yeah, I had to dig up this ancient old laptop, but it's fine. We will persevere. If that's not a real problem, so I'm good. How about you?
All right. My space bar works great. So, I mean, I'm not trying to brag or anything. But, there we go.
Nothing to complain about. Okay, well, let's start the show with a special shout out to the law firms who knuckled under and agreed to provide pro bono services to the Trump administration, because it looks like you guys just got your first official assignment, and it's defending cops who beat civilians. So, mazel tov, well played.
Yeah, this came in the form of an unbelievably dangerous executive order that Trump released right as we were about to record tonight. In it, he proposes to, quote, empower state and local law enforcement to firmly police dangerous criminal behavior and protect innocent citizens, and he's going to empower them by making sure that there are no checks on their behavior. And he's instructing the Attorney General to, quote, provide legal resources and indemnification, right? That is, defending and reimbursing law enforcement officers who unjustly incur expenses and liabilities for actions taken during the performance of their official duties to enforce the law. This mechanism, I'm still reading from the EO, this mechanism shall include the use of private sector pro bono assistance for such law enforcement officers, end of real quote. So congrats, Skadden, Paul Weiss. You guys are now the new lawyers for the next Derek Chauvin. The next time there's a cop who kills a civilian, you will get to defend him. I am positive that will be a major inducement for, those second years who are toiling away 80 hours a week in the basement at Doc Review to, feel fulfilled professionally and morally. I'm a little pissed about this.
Yeah. And how'd you like a little bit of martial law to go along with that? Because the same executive order instructs the Attorney General and the Secretary of Defense in consultation with the Secretary of Homeland Security to, quote, increase the provision of excess military and national security assets in local jurisdictions to assist state and local law enforcement. And in case you thought that meant giving outdated tanks to the sheriff of Podunk County like they used to do, no. These guys make it clear that the AG is supposed to, quote, determine how military and national security assets, training, non-lethal capabilities, and personnel can most effectively be used to prevent crime.
Did no one ever teach these guys about the Posse Comitatus Act? I mean, maybe it's too woke, but we passed a federal law during Reconstruction in the 19th century that says Whoever, except in cases and under circumstances expressly authorized by the Constitution or Act of Congress, willfully uses any part of the Army or Air Force as a posse comitatus or otherwise to execute the laws shall be fined under this title or imprisoned not more than 2 years or both. What that means is it is a felony to use the military to police civilians unless there's a direct act of Congress, which there is not here.
Yeah. And I mean, Trump may be indemnified by the Supreme Court for this criminal order, but that doesn't mean that the people who carry it out are.
We've been saying that since day one of his presidency, since January 20th, right? Like the weak point are Trump's henchmen, and that, we need to get more people who are terrified to carry out his wishes.
Hear, hear. Okay. Let's do docket alerts. I don't know whether we should have like a jaunty little dun-dun at the end of such a terrifying pronouncement. Yeah. Okay. So the government, as we said, is getting sued everywhere all at once, which is probably for the best and will certainly remain that way for a long time. For better or for worse, this is how we fight, or at least one of the ways we fight. So let's start with some of the suits which were filed this past week. A coalition of 19 blue states sued the Department of Education in federal court in Massachusetts over threats to withhold $13.8 billion in funding to educate children in states which teach radical DEI, which, whatever that means.
I mean, it sounds like you're kidding, but whatever that means is kind of the point, right? Trump put out 3 executive orders targeting so-called DEI in his first week in office alone. In one, he called for ending radical indoctrination in K-12 schooling, by which he meant eliminating federal funding or support for illegal and discriminatory treatment and indoctrination in K-12 schools, including based on gender ideology and discriminatory equity ideology. I mean, he has just made it clear over and over again that he thinks DEI is illegal and that it violates Title VI of the Civil Rights Act. And that's exactly backwards. But I mean, no one can really know what DEI is to this administration.
Yeah, I did a video for Legal Eagle on the government stealing school lunch money from Maine because a couple trans kids are running track with their classmates. Mm-hmm. The Trump administration basically takes the position that allowing trans kids to play sports violates Title IX because it discriminates against girls to make them play with, quote, boys, which is how they refer to trans girls. I mean, it's not clear to me whether the courts will uphold the right of trans athletes to play sports under Title IX. Some courts have and some courts have not. And obviously the Supreme Court has been sort of hostile to the rights of trans individuals. But no court in this country has ever said that letting trans kids play sports violates Title IX. And yet the feds now demand that everyone treat their brand new made up interpretation of the law as binding precedent, which is, is filthy, obviously. But look, in the case of trans kids, it's sort of clear, like what you were saying about whatever that means. I think this interpretation of the law is clearly wrong, but Maine knows when they allow trans girls to play sports that they are violating it. With respect to DEI, like, how the hell do you know if you're violating it, right? The order says discriminatory equity ideology means an ideology that treats individuals as members of preferred or disfavored groups rather than as individuals and minimizes agency, merit, and capability in favor of immoral generalizations. And those are all words. So they provide some examples like an individual by virtue of the individual's race, color, sex, or national origin is inherently racist, sexist, or oppressive, whether consciously or unconsciously. No school's teaching that. Come on. I mean, that's just a bullshit way to make it illegal to talk about systemic racism and subconscious bias, which they couldn't do, right? That would clearly violate the First Amendment.
Right. So on April 3rd, the Department of Education sent letters to all the states saying, basically, certify that you're DEI free or we're cutting all of your education funds. And the case that they cite as proof of their DEI is unlegal policy is Students for Fair Admission versus Harvard. That's the Supreme Court decision that struck down the last vestiges of affirmative action in university admissions, which, look, you and I have gone on at great length about how that is a terrible decision, and it is, but For as terrible as it is, it definitely did not say that DEI initiatives, as they are currently understood in corporate and educational America, are illegal, right? And it absolutely, positively did not say that teaching about systemic racism, which is a real thing, violates Title VI. That's crazy. Look, the Supreme Court's affirmative action jurisprudence is, to put it kindly, incredibly convoluted. But just this term, the Supreme Court has twice reaffirmed that public schools and universities can value diversity as a goal. And they let stand a 2023 decision, they failed to grant cert, by the Fourth Circuit. That was a case called Coalition for Thomas Jefferson versus Fairfax County School Board. The school was Thomas Jefferson High School, was a magnet school, and they had an admission program that was designed to, quote, promote diversity in many forms, and the program specifically tracked Black enrollment, which, by the way, was classified as too small for reporting. So you can understand why they wanted to track it, right? So my point is that the idea that the Supreme Court, even this Supreme Court, as conservative as it is, has signed on to the Trump administration's view of DEI, that's just not the case. It is not true.
Right. And I think being deliberately vague is strategic, right?
Uh-huh.
If you don't know what the administration thinks DEI is, you will police yourself and you will overcorrect, right? That's why you've seen all these stories about books about Harriet Tubman and the Tuskegee Airmen being pulled off of the shelves. Mm-hmm. So the states were like, this isn't going to work. This is how Wisconsin Attorney General Josh Kaul described the totally untenable situation. He says the letter forced state and local agencies to choose between two untenable options. One, refuse to certify compliance based on the department's undefined viewpoint on what constitutes unlawful diversity, equity, and inclusion programs, curriculum, instruction, and policies, and place federal funding in peril. Or number two, certify compliance, attempt to identify and eliminate lawful diversity, equity, and inclusion to the detriment of students, and still face liability for failing to fully comply with the department's vague and ill-defined order.
You know, I really like Josh Kaul.
Yeah, I do too. I mean, I don't want to tell Wisconsin which politicians to elect, but that guy seems awesome.
I do.
No. It's always, you always get milkshake ducked when you're like, I think this is a politician that I like. Maybe the state should, and then you always live to regret it. Okay, so obviously the blue states refused to sign the No Woke Pledge and instead sued, claiming that the letter violates the Administrative Procedures Act because there is a procedure to claw back educational grants based on a finding that student civil rights were violated, and this ain't it. Also, you can't just randomly, after money has been granted, impose new terms, such as sign the No Woke Pledge.
Yeah.
The case has been assigned to Judge William Young, who has been on the bench since literally 1985. He's a Reagan appointee.
I never thought my career would get to the point where I'm cheering that on. But look, anybody who was put on the bench by Ronald Reagan is probably a communist compared to most Trump appointees. So I'm all for it.
Yeah, I mean, this guy took senior status, opening up a slot for President Biden to replace him in March of 2021, 5 minutes after Trump left office. So make of that one what you will.
Yeah, I don't think there are two ways to read that one. So, okay, that case was just filed on Friday. The states have only asked for declarative relief as of yet. I assume that they will ask for a TRO this week. We'll continue to monitor. But since we're talking about judges, I will point out Donald Trump has not nominated any yet. I mean, look, no hurry, big guy. Take your time. We got nothing but time here.
Yeah, don't let him hear you about that. I would suspect that he's still trying to get all his weirdo executive branch nominees through, like Ed Martin.
The acting U.S. attorney for the District of Columbia. Yeah, that guy, the guy who wants reparations for January 6th rioters and is seriously threatening this week to put Wikipedia in jail.
Yeah, I mean, I still hold out hope that Republicans might not confirm that loon, although they did confirm Kash Patel to head the FBI.
Robert F. Kennedy Jr. Yeah, the Republicans in Congress have not covered themselves in glory on this one.
Yeah. Okay, it is Tuesday, so we are going to thank our new subscribers this week on Substack at lawandchaospod.com. Thank you to Abacus NS, Sam, Anonymous, Justic Balick, Yulia, Susan Niblo, Catherine Reed, and Rebel Without a Pause.
And on Patreon, over at patreon.com/lawandchaospod. Thank you to Knife of Ice, Eddie Delecto, Seth Jackson, Shira, Vibe Check, and Christian Porter. And if you'd like to join their ranks, you know how to do that. Just head on over to lawandchaospod.com to sign up on Substack, or patreon.com/lawandchaospod, and you will get the shout out. You will get the show ad-free. You'll get all the benefits, and you'll help us continue to bring this show to you, which, we'd like to keep doing. And also, if you're a subscriber, in this episode, we have a deep dive into the unholy alliance of conspiracy theorists and libertarians over at the Food and Drug Administration. This one involves raw milk and bird flu and probably chemtrails by the time we get finished.
And it involves kashrus, Jewish dietary laws, the 19th century Pale of Settlement.
I cannot wait.
And probably listeria.
Yeah, that one not so much.
All right. Stick with us, guys. We'll be right back after this brief ad break.
Okay. The next complaint filed against the Trump administration is the American Bar Association suing the government over canceled grants to fight domestic violence because these people in the Trump administration are filth. This started with a memo from Deputy Attorney General Todd Blanche on April 9th that tried to say that it was all well and good for the ABA to say stuff that disagrees with the government, but suing the government is another matter entirely. And now that the ABA, which receives grant funding through USAID, is a plaintiff in one of the impoundment cases, it has been declared persona non grata over at the Department of Justice.
Yeah, I'd just like to point out that seeking redress of government is core First Amendment activity.
Yeah, it absolutely is. And look, Todd Blanche absolutely knows that. So in his memo, he says that the department will no longer pay for staff to attend ABA events or even allow them to use their official titles if they pay to go there on their own time. Like Blanche goes so far as to say that, quote, ABA-related activities shall not qualify under the de minimis personal use exception for the use of department property or resources. So using so much, I mean, de minimis means, of minimal, virtually zero value. So using so much as a Post-it note from the office to jot down the dates of a conference or one paperclip, right? Like that will violate Blanche's ban on using taxpayer dollars to support the American Bar Association.
Yeah, two thoughts here. One, Todd Blanche is such a petty bitch. And two, way to announce that you're absolutely, positively retaliating against an organization for exercising its First Amendment rights.
Our Todd is nothing if not obvious. So,
yes,
okay, the next day after Blanche's memo, April 9th, the Department of Justice canceled $3 million in grants under the Violence Against Women Act for the ABA's Commission on Domestic and Sexual Violence. And they left intact grants for other similarly situated grantees, which is very subtle, right? So the ABA now is suing for violation of the First Amendment, viewpoint discrimination, that they say that it violates the spending clause to use federal funds to regulate speech unrelated to the federal funds themselves. And they're right? They also claim that it violates the Fifth Amendment's Equal Protection Clause. They claim violation of procedural due process because, there's a way to terminate grants. And again, this ain't it. And of course, they have an Administrative Procedures Act claim. So this case is in federal court in the District of Columbia. It is assigned to Judge Christopher Cooper, who is an Obama appointee.
Yeah, I think this is yet another sign that the legal community has finally understood that we have to stand up to Trump together. Mm-hmm. Like whatever those Vichy law firms that are going to be, representing cops did, to get Trump off their back, it's going to come out in court. We are going to find out about this. This is not going to remain sealed. You saw Judge Beryl Howell ask about it last week in the preliminary injunction hearing in the Perkins-Coie case.
Yeah, she said, I can't wait for the FOIA requests.
Yeah, right. And my email is basically unusable today because I'm being inundated with notices of amicus briefs in the Jenner and Block and the Sussman Godfrey cases. Those are two more of the firms that challenged the executive orders targeting them. Like, I really do think that lawyers are finally waking up to the danger to the rule of law itself.
Yeah.
So, and I see this case as part of that. Okay, I do want to talk about some of the immigration cases we are following. But first, an update on the Trump administration's effort to burn down the Consumer Financial Protection Bureau. Essentially, Project 2025 true believer Russ Vought, the head of the Office of Management and Budget, and now the acting head of the Consumer Financial Protection Bureau, fired all the employees at the CFPB and turned the agency off 5 minutes after he got confirmed. And then the employees sued in a case called National Treasury Employees Union v. Vought.
Yeah, Vought is really a modern-day Rasputin. I mean, colorless and boring, straight out of Central Casting as the hapless vice principal, sure, but so strategic and so evil.
Yeah, so NTEU v. Vought is in 2 federal courts in D.C. at once. In the district court, it's in front of Judge Amy Berman Jackson, who ordered CFPB to hire back the 80% of staff fired by Vought in March. And at the same time, it's on an interlocutory appeal to the D.C. Circuit, where it got that hell panel for emergency appeals, which will rotate out this week, thank goodness. Remember, D.C. Circuit has an emergency panel that sits for a month, and this month's panel contains 2 Trump appointees, Gregory Katsas and Naomi Rao, plus Obama appointee Cornelia Pollard. So in the trial court, Judge Jackson said, no, Russ Vought, you can't torch the congressionally created agency that protects consumers from being ripped off by big business. You have to reinstate all those probationary employees, and you cannot institute an agency-wide reduction in force or a RIF. You can only fire employees based on an individualized assessment of their performance and the agency's requirements. And she said, P.S., no screwing around by locking these people out of their offices or taking away their online access or shutting off their emails or whatever, which is the reason she had to say it is because that's what they were doing. So the government appealed, and the Hell panel said, nah, go ahead and fire who you want. Do a RIF, but you have to do it based on an individualized assessment of each employee's work and the agency's statutory requirements. You can't just fire everybody and salt the earth so that the agency can never be put back together again, which is exactly what the plan was. Anyway, so at that point, Russ Vought was like, hooray, it's RIF time, and he fired 90% of the staff.
Yeah, that supposed careful, individualized determination that the D.C. Circuit ordered took a week, and the resulting reduction in force was larger than the original mass non-individualized layoffs that got enjoined, right? At least according to the declaration filed by Mark Paoletta, the general counsel at Office of Management and Budget and Ginny Thomas's best friend. He's like the Zelig of the American right. He is also super tight with Justice Clarence Thomas's sugar daddy, Harlan Crow. He has represented Ginny Thomas when she was subpoenaed by the January 6th committee. He's basically spokesperson for the Thomases too, now that I think about it. So anyway, Paoletta submits this declaration that's me and the boys went through it line by line, and we made this very particularized determination. I mean, here's a bit of this dumb filing. Paoletta says, the Research Monitoring and Regulations Division consisted of 230 employees. Within RMR, the Office of Service Members Affairs, Office of Protection for Older Americans, and Office of the Private Education Loan Ombudsman are statutorily required. I determined that the statutory duties of each could be performed by one person. The research unit is also required by statute. I determined that 3 employees are sufficient to perform the statutory duties of the research unit. Monitoring is also required by statute. I determined that 4 employees were sufficient to perform the statutory duty. I also determined that 10 employees for regulations and 2 for the front office would be sufficient to perform these non-statutorily required functions. I thus determined that 22 employees would be sufficient for the RMR division.
Right, so a 90% cut, which does not honestly sound very particularized.
Yeah, no, the plaintiffs didn't think so either. So they demanded to depose Paoletta and, ask, how'd you come up with those numbers? And where's the supporting documentation that would back up your claims that these are a particularized and individualized decision, right? At which point, the Office of Management and Budget was like, how very dare you invade the attorney-client privilege? Don't you know Mark Paoletta is a lawyer?
Right. I mean, we just went through this in the Abrego Garcia case. Like, if you submit a declaration from your lawyer, it's going to make it a lot harder to claim privilege when the other side wants to depose him. Anyway, Judge Jackson scheduled a hearing for April 29th on the issue of this RIF, and she ordered Paoletta and Adam Martinez, CFPB's chief operating officer, to testify. But meanwhile, OMB raced back to the D.C. Circuit and said, help, help, Judge Jackson is persecuting us. But then a weird thing happened today as we're recording, which was that the appellate panel, or two of the three judges anyway, seem to have decided that the government is acting in bad faith, if you can even believe it.
Yeah, and again, this is that very conservative panel. So this one requires reading between the lines a little bit. So let me read a little bit of the order, and then, Liz, you and I can talk about it. So the panel says, our partial stay order permitted defendants to conduct reductions in force of employees whom defendants have determined, after a particularized assessment, to be unnecessary to the performance of defendants' statutory duties, that is, of the CFPB. The parties vigorously dispute whether this language permits judicial review of the questions, whether the assessment at issue was particularized, and whether the employees subject to the RAF are unnecessary to the performance of the CFPB's statutory duties. Plaintiffs highlight that the proposed reduction in force currently at issue, involving nearly 90% of agency employees, exceeds the scope of the original RAF that prompted the district court's original preliminary injunction. Given these ongoing disputes, we think it best to restore the interim protection of paragraph 3 of the preliminary injunction that was issued by Judge Jackson, which ensures that plaintiffs can receive meaningful final relief should the defendants, that is the government, not prevail in this appeal, rather than continue collateral litigation over the meaning and reviewability of the particularized assessment requirement imposed by this court's stay order.
Right. So in English, they're saying, look, if this is going to devolve into a protracted dispute about what a particularized assessment is, like, forget it. We'll just expedite the merits review and we can go back to Judge Jackson's original order, or at least the part where she said, no, you guys can't do a RIF. And Andrew, I think you and I agree that this is potentially a pretty big deal.
Yeah, I think we kind of buried the lead here, which is that the two conservative judges split, right? Judge Naomi Rao had a typically Judge Rao dissent that I've read like a press release from the Trump administration, right? She made dumb noises about the all-powerful executive. She refers to him as President Trump on every line, right? But Judge Gregory Katsas, again, very, very conservative judge with terrible rulings on the D.C. Circuit, sided with Judge Pillard and said, no, we are not going to take the government's word for it that it made individualized determinations for every employee for thousands of employees in like a week and a half. And look, we've now seen this play out a bunch of times, right? Like in the USAID cases where the Trump administration said, well, we spent 4 days and now we've decided that 92% of USAID contracts are unnecessary or don't comply with the president's priorities, or with all of those tiny agencies like the U.S. Institute for Peace or the U.S. Africa Development Fund, where, you know, the government came in, they took agencies with congressionally allocated budgets in the tens of millions of dollars, and they said, it complies with federal law to leave one employee and one grant of less than $100,000. That's what they mean when they say statutory minimum level that they can reduce those agencies to and still be compliant with Congress, which is ridiculous. Okay. I think that it is significant that you have a very conservative judge on the DC Circuit where almost all of these cases are filed saying, one, no, that cannot be the statutory minimum. Come on. And two, we are not going to take the Trump administration's word for it that you didn't just slash and burn and then sign an affidavit, attesting that you hit it with a scalpel.
Yeah, I think it's important too, because the DC Circuit has really been loath to weigh in on these impoundment cases, right? These spending cases. And the same for the firing cases, right? This is where they've kind of allowed the Trump administration to fire all of these agency heads who are not supposed to be fireable. And I think the pushback here on, you can't keep burning these agencies down, particularly because, right, like Judge Beryl Howell, I believe she's the judge in the U.S. Institute of Peace case. And she said, I can't stop you from doing this. And it looks to me like you're finally getting the D.C. Circuit to a place where it says, yeah, maybe we can. We can maybe stop you. We can maybe evaluate. Maybe it doesn't violate the separation of powers to look beneath the hood and not just trust you when you say, well, I'm just, statutory minimum. I'm doing my job.
Yeah, I think that's exactly right.
Okay, we're going to take another ad break and we will be right back with you on the other side. And we're back. Okay, let's talk about the immigration cases because we discussed several of them in the written post yesterday at lawandchaospod.com.
Nice
But
plug.
I just want to go through a few of these because it's really where the rubber's meeting the road between the Trump administration and the courts. Like, they've been squirrely in the cases about spending and firing federal workers, but they've been outright defiant of courts in the immigration cases. Although I guess I don't want to lose sight of the fact that the immediate and most drastic effect is on the poor people, human beings caught in this evil shit show.
Yeah.
Because the thing that stands out the most is the use of cruelty as a weapon that the administration wields as a matter of policy. Like, they've been deporting multiple young children with cancer to places where they're not near their doctors. They don't have their drugs. It's just abject cruelty. Or like last week, a Cuban woman with an American husband and children showed up for a routine check-in and was summarily deported. She was actually ripped away from her infant child, whom she was breastfeeding, so they could deport her. That's cruelty as policy. It's the same as the child separation policy from the Trump administration, which will undoubtedly be back soon if it isn't already. Although, I mean, in some sense, it's kind of worse, right? Like the theoretical purpose of the child separation policy in the first Trump administration was to deter people from coming here. This is just, well, we got a quota of people we got to deport, so too bad, so sad for you. You're not doing anything terrible. You're already here. You're under supervision, but you showed up for your regular appointment and you got to go. So I'm not sure if it's which is worse. They're all different degrees of horrible. Okay. The second thing we're seeing playing out in these immigration cases is an attack on the rule of law globally. Like, you have the Trump administration officials saying undocumented immigrants aren't entitled to due process. That's literally a thing that they have said. It's completely un-American. And they usually pair that with an invocation of the name of some victim of violent crime perpetrated by an immigrant. So if you say Kilmar Abrego Garcia is entitled to due process, you shouldn't just summarily dump him in a Salvadoran jail when there's a court order saying he shouldn't be there. They say, well, Rachel Morin never got due process. Morin was a Baltimore woman killed by an immigrant.
Ipso facto, a different immigrant who has nothing to do with her should be sent to a Salvadoran gulag in violation of a court order like that. That logic doesn't even make sense on its own racist terms.
Right. And then sort of the third thing that we're seeing in these immigration cases, maybe it's just a thing with you and me, Andrew, but we go back and forth all the time about whether there is a top-down strategy here, a whole of government strategy that includes the lawyers arguing for the government, or whether ICE is just kind of wilding out, like arresting and deporting people at will, and then telling the DOJ to back formulate an argument to justify it later. I mean, I think, Andrew, you're in the former camp and I'm in the latter. But maybe we'll come back to that after we talk about these cases. Because first we have that deported 2-year-old American citizen in Louisiana. The mother showed up on Tuesday for a regular check-in with her immigration officials. She had her 2 children with her, the toddler who was born here and the 11-year-old who immigrated from Honduras with her parents. And at that check-in, as ICE has been doing, basically, they took her and the kids into custody and held them more or less incommunicado for 3 days before loading them onto a plane and dumping them in Honduras, including the baby, who is a U.S. citizen. And by the way, the mother is also pregnant.
Yeah, this case is shocking on all the levels, right? Like, during the 3 days that ICE held them, the father tried desperately to get the children out, including signing custody over to their aunt, who is a U.S. citizen, in official notarized documents that contained the children's birth certificates. And ICE just refused to release the kids unless the father showed up in person to check in with ICE. Like, it is pellucidly clear from the correspondence that ICE was basically holding the kids hostage, hoping that the father would show up and then they could physically deport the entire family together. And He didn't do that. In the meantime, lawyers on behalf of the family filed a habeas petition and a motion for a temporary restraining order to get the mother out, and then the government deported her anyway with the kids.
Yeah, that is the most shocking part of all this, right? The government produced this handwritten note that said, I am taking the baby to Honduras, and then it was in Spanish, as proof that she wanted to keep the child with her. And maybe she did. We don't know. Maybe she was just documenting where the child was in hope of getting word to her husband. I mean, we don't know what they told her. Maybe ICE told her if she didn't take the baby with her, they were going to put the baby up for adoption. God knows what these people would say. I mean, maybe she was just documenting where the child was in hope of getting word to her husband. But whatever it is, they made damn sure she wasn't able to tell anybody, because they wouldn't let her speak to anybody, including lawyers who were trying to speak to her. By the time the court tried to figure out what went on here, the mother and the children had already been cut loose in Honduras.
Yeah, and I'm glad you went through the human tragedy aspect, because I want to talk about the rule of law aspect, right? And that is that this case went before Judge Terry Doughty of the Western District of Louisiana. Now, Doughty is a wingnut loon, right? We have criticized him on this show and in print on multiple occasions. He's the one who said that the Biden administration violated the First Amendment by flagging COVID misinformation on social media, right? His solution was to bar the Biden administration from talking to social media at all. That got overturned by the Supreme Court, if that gives you a sense of how, out there he was, right? So this case lands on Doughty's docket on Thursday afternoon. He calls ICE up at roughly 12:30 on Friday, and ICE says, "Oh, too bad, so sad. We just dumped the family in Honduras." And so Judge Doughty puts out an order saying, let me quote it directly, "The government contends that this is all okay because the mother wishes that the child be deported with her, but this court doesn't know that." And then he says that he has, quote, "a strong suspicion that the government just deported a U.S. citizen with no meaningful process." So the matter is now set for a hearing in 3 weeks.
Yeah, I mean, look, when you've lost Terry Doughty,
and Gregory Katsas,
right, you screwed up. I mean, I'm totally serious here. Thanks in large part to these immigration cases, the government writ large, and specifically the Justice Department, has essentially burned through every shred of credibility it ever had with federal judges. And it had a lot, right? The government enjoyed a presumption of regularity, which is the kind of term of art. But basically, courts would, if the government said something, courts would more or less automatically credit it as true, and they clearly don't anymore.
Yeah, and we also wrote about a second immigration case yesterday on the blog where another federal judge called the government out on its bullshit, right? That case involved a couple from Venezuela whom the government keeps trying to deport, including by falsely claiming that they are members of or associates or affiliates of Tren de Aragua. And the evidence is basically, well, the wife's first husband, who was killed a decade ago, was possibly a member of Tren de Aragua. So she's a Tren de Aragua associate, and then so's her second husband.
Yeah, by the transitive property.
Right. And so a federal judge in Virginia already said a month ago that the state's evidence was garbage. But the government has detained these people twice more since then. And now a second judge in Texas has reamed the government out, making a judicial finding that these people are not Tren de Aragua. They are not deportable under the Alien Enemies Act. And on top of that, he ordered the government to give notice to any Alien Enemies Act purported deportee written in the language they speak, apprising them of their right to challenge the order in court and giving them 21 days to do it. Now, that is not a nationwide injunction that applies only in the Western District of Texas.
Yeah, although there are other orders in, I believe, the Northern District and the Southern District of Texas, because there are a lot of AEA detainees in Texas. But, we've talked about Jewish dietary laws, mostly in the Patreon bonus. Basically, you can tell what people were doing by what the rules say. Don't do that anymore. And the reason that Judge Briones, that's the judge who did this, has put out this very specific order, is that the Justice Department has been not doing it, right? The Justice Department took the position that 12 hours satisfied the Supreme Court's order to give these people due process. They're like, the Supreme Court said, there has to be a meaningful opportunity to challenge deportation. And the Justice Department says, well, 12 hours does it, and they said it doesn't have to be a notice that is in Spanish or whatever language the deportee speaks. It doesn't have to mention that they have a right to challenge it, right? And so this is once again the court saying, you're full of crap. Like, we don't believe you. Look, before the Supreme Court's ruling, the government took the position that the president labeling someone a foreign terrorist actor under the Alien Enemies Act was a wholly unchallengeable designation. I mean, I guess in retrospect, it's funny because at the time we were like, well, this is crap. But in retrospect, I guess we should thank the Supreme Court, for giving the detainees process.
I never thought we'd be there, but I think that's right, that Chief Justice Roberts was trying to let the Trump administration back out of this gracefully. Why he thought that would happen, I don't know, but you have made this point in print on multiple occasions, and I think he was kind of genuinely shocked that they didn't, and more judges are sort of falling into the realization that Chief Justice Roberts went through, right? I think that's what Judge Katsas is going through, and maybe Judge Doughty.
Yeah. I mean, I think that maybe I just want to be super clear about what we're talking about here, because maybe you haven't been following along. In the beginning, there was the JGG case before Judge James Boasberg, and Judge Boasberg put out a nationwide injunction that said, I'm going to allow a challenge under the Administrative Procedures Act, which has a slightly lower threshold. And I'm not going to allow any deportations under the Alien Enemies Act nationwide until we, sort this out. And the Supreme Court said, no, the Alien Enemies Act isn't the right way to challenge. It's habeas corpus, which is a higher threshold and has to be filed in the jurisdiction where people are being held. So that the proper jurisdiction, since most of these deportations are taking place out of Texas, is Texas, which is in the Fifth Circuit, which is extremely hostile to, favorable to the government and hostile to immigrants. Okay. So when this order came out, overturning Judge Boasberg's ruling and kind of kicking the case out from under him, we thought it was bullshit, and I think most people thought it was bullshit.
It's still bullshit, but
I think it's still bullshit too. But that the Supreme Court saying yes, these people are entitled to process. I think trial judges, seeing that it was bullshit, have really seized on that. I mean, I was sort of joking. I don't give credit to the Supreme Court at all for this, but I definitely give credit to the trial judges who are standing up and saying, okay, if you, the Supreme Court, are going to kind of wink and nod and say, yeah, no, there's process, but what you really mean is, please, Trump administration, make this case go away, which they, of course, didn't. The process is really being given life and meaning by the trial courts.
I think that's exactly right.
Okay, we're going to take one more ad break, unless you're a subscriber at patreon.com/lawandchaospod or lawandchaospod.com, in which case you are not going to have an ad break. You are never going to have an ad break. Isn't it magic? And we're back. Okay, this one is not a lawsuit against the Trump administration. It is some absolute bullshit by the Trump administration, because in Wisconsin, the Justice Department filed a federal criminal complaint against a 65-year-old state court judge, Judge Hannah Dugan of the Milwaukee County Circuit Court, charging her with obstruction of justice and unlawful concealment of an individual subject to arrest. I'm sure you guys have heard about this because it's been all over the news. Yeah. Here are the facts as alleged by the government. On April 18th, Eduardo Flores Ruiz was scheduled to appear before Judge Dugan for a hearing at the Milwaukee County Courthouse. So ICE officers traveled to the courthouse to arrest Flores Ruiz after the hearing. Judge Dugan asked the officers who were standing in the hallway outside her courtroom if they had a court appearance, and they said no. And she asked if they had a judicial arrest warrant, and they They said that they didn't have that either. What they had was an administrative warrant.
Yeah, put a pin in that one. For now, the important thing to know is that an administrative warrant does not authorize ICE to arrest anyone in a non-public space.
Right. So then, knowing that ICE was just there to ambush a defendant in her courtroom, Judge Dugan and another judge went to get the chief judge to figure out what the hell they were supposed to do. And the chief judge was only available by phone, but he said that they could not arrest anyone in courtrooms or other private locations within the courthouse, but they could effectuate an arrest on the courthouse steps or in the hallways. So after Flores-Ruiz's hearing, Judge Dugan escorted him and his lawyer out through the jury door into what's called the non-public area of the courthouse. So, like, if you've ever sat for jury duty, there's like a jury room that's kind of adjacent.
But I haven't.
Yeah, which I always do. Yeah, it's adjacent to, you kind of leave through a special door so that the jurors are often segregated from the defendant, obviously, and from the people in the stands, right? Because you don't want to have like them talking to the witnesses. They're supposed to be segregated. So generally, the jury, like, there's a jury room, and it leads to the common hallway. But I think it's fairly clear what happened here is that Judge Dugan said, you go out through the jury door, right, and hope that this guy could evade being arrested in the hall, which is not what happened, right? As soon as he came out of the jury door, you're in the common hallway, and he took the elevator down to the 4th floor with the DEA agent in the elevator. Right. And when they got off and left the courthouse, they tried to arrest him, and he ran for it, and 2 FBI agents chased him for about a block and a half, and then they, arrested him. Fine, done. That's the whole thing. So Judge Dugan is charged with obstruction under 18 U.S.C. 1505, and she's charged with unlawful concealment under 18 U.S.C. 1071, which makes it a felony to harbor or conceal any person for whose arrest a warrant or process has been issued under the provision of any law of the United States so as to prevent his discovery and arrest.
Yeah, and each of those 2 criminal sections carry a 5-year prison sentence maximum, right? They are felonies. And to be clear, there is absolutely no basis for charging Judge Dugan with either of those, right? Even on the facts as asserted by the government, as you just recited them, Liz, right? And they're really 2 things embedded in the law that are the key to understanding that this is just 100%, obviously a ham-fisted effort by the Trump administration at intimidating a judge that stood in the way of their ICE officers. So the first is the Fifth Amendment's grand jury clause, right? The Fifth Amendment begins, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. And as a sidebar, I know we're late, but the right to be indicted by a grand jury is one of the few provisions of the Bill of Rights that has not been incorporated out to the states by the 14th Amendment, right? Incorporation, we've talked about this on the show before. The First Amendment says Congress shall make no law abridging the freedom of speech. So before 1865, that meant if, say, the state of Maryland passed a law abridging the freedom of speech, you could not go to the Supreme Court to have that Maryland state law declared unconstitutional because the Maryland legislature isn't Congress. That was it. End of. But after the Civil War, we passed the 14th Amendment, and it says, no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States or deprive any person of life, liberty, or property without due process of law. And so the Supreme Court then said, look, that means states can't violate the Bill of Rights, and they set about incorporating one by one, defining what counts as either privileges or immunities and can be abridged, or liberties, and interestingly, that did not include the Second Amendment right to keep and bear arms until 2010. That was a case called McDonald versus City of Chicago, and man, do I have a deep dive on that one.
We're gonna have to come back to that one.
Oh, you are no fun. Anyway,
tell me
TLDR, the Fifth Amendment's grand jury clause is one of the few remaining provisions in the Bill of Rights that has not been incorporated to the states. And there's like a ton in the academic literature about whether the right to be indicted by a grand jury for a felony for an infamous crime is really an individual liberty interest or not.
Yeah, and I am interested in that. But I think the more important point here with respect to Judge Dugan is that the federal government needs to go to a grand jury to indict any criminal defendant for an infamous crime, which is defined as a felony that carries a potential sentence of a year or more, which both of the crimes that she's theoretically charged with do.
Yeah.
So look, we're obviously on this, grand jury rabbit trail because Judge Dugan was not indicted by a grand jury. Right. She has this complaint filed by the Department of Justice and signed off on by a magistrate judge who, not clear what happened with that magistrate. But anyway, Judge Dugan cannot be held to answer for her supposed crimes unless and until a grand jury hands down an indictment, which seems highly, highly unlikely.
Yeah, right.
Now, look, it's not crazy to think that there would be a criminal complaint before there was an indictment. We just saw that happen with Luigi Mangione in federal court, that there was a criminal complaint, and then, Pam Bondi went and flapped her yap about how he was going to get the death penalty, and then they bothered to actually indict the guy. So it's quicker to file a complaint than it is to get an indictment. So if you think you have a person who's a danger to the community or a flight risk and you need to detain them right away, the Justice Department can file a complaint. And then if a magistrate judge agrees there's probable cause, the judge can issue an arrest warrant on the complaint. And then after that, the government can go to the grand jury and the defendant's in custody, and they can get an indictment there. The second reason that the government might file a complaint and not a grand jury indictment is if it believes it's going to reach a plea deal with a particular defendant. So you can waive the grand jury clause of the Fifth Amendment if the guy's about to flip. You don't need to go to a grand jury and go through the whole process.
Yeah, but critically, neither of those apply to Judge Dugan, right? She's not a flight risk. She's not a danger to the community. She's certainly not going to flip. So I have to say, I mean, you implied this, I do not know what the magistrate judge who signed off on this complaint and the arrest warrant was thinking, but I infer the reason that this proceeded by criminal complaint and not by an indictment is because the DOJ knew or strongly suspected that a grand jury would not have issued an indictment, right? And, if you've watched Law and Order or any, criminal justice procedural, you've heard that old adage that a grand jury will indict a ham sandwich, right? That's because a defendant, apropos of the literature we've talked about, a defendant does not have a right to appear before the grand jury. They do not have the right to have their lawyer present. They do not have the right to cross-examine the government's witnesses, right? It is a one-sided presentation by the government of the evidence.
Yeah, I mean, I don't know what the magistrate was thinking here, but I have a pretty good idea what the feds were thinking, which is that they wanted to, look, Pam Bondi went all over Fox and said, these judges are out of control and we're going to prosecute all of these judges. And, Kash Patel, who's the head of the FBI, tweeted out a photo of this woman being arrested and handcuffed in her work. So, yeah. This was clearly an effort to intimidate judges, writ large, state and federal.
Yeah, I think that's right. Okay, so first fact is that this was a criminal complaint, not an indictment handed down by a grand jury. The second thing is that there was no pending judicial warrant for Flores Ruiz's arrest, right? We're going to pull that pin from the hearing itself, right? This is another distinction that, in any sane universe, nobody should have to know this other than immigration lawyers, but now we do in Trump's America. And here's the way to think about it. What we are calling a judicial warrant is a real warrant, right? The Fourth Amendment to the Constitution says that people have a right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. So a Fourth Amendment warrant says that a law enforcement officer has gone to a state or federal judge and convinced that judge that there is probable cause for the officer to search a particular person or place with particularity or make an arrest.
And an administrative warrant, which is sometimes called an ICE warrant, is none of those things. It can be issued either by the Department of Homeland Security, which supervises ICE, or by an immigration judge or officer. So there's no separation of powers or neutral review here. This is just ICE telling itself that it thinks it has the right to seize or arrest a non-citizen, which means it is not a warrant for the purposes of the Fourth Amendment. It does not authorize a search of a person or premises. And anywhere you have a reasonable expectation of privacy, like your house or any non-public place, ICE may not execute an administrative warrant, and it can't demand to be let in.
Yeah. Don't take legal advice from a podcast or anything, but here's what the National Immigration Law Center says about ICE or administrative warrants. They say, If immigration agents approach your resident with a, quote, warrant or subpoena, do not open your door. Opening your door when a law enforcement officer comes to it can be construed as you are having consented to a search and seizure that is permissible under the U.S. Constitution. Law enforcement and immigration officers may not enter private areas unless they have a valid judicial warrant or the consent of a person who is authorized by the entity occupying those private areas to allow people to enter them. If immigration authorities come to your door without a warrant and you open the door and they search your house, they will argue that their search was lawful because you consented to it by opening the door. Therefore, if they come to the place you live with a warrant, subpoena, or some other document, ask them to slip it under the door or hold it up to a window. If you can, take a photo of the document. So I'll link to it in the show notes, but yes, this is what ICE does, right? And by the way, this is what they did under Obama and Biden as well as Trump, right? They live in this space that requires someone who likely does not speak English to understand the difference between a judicial warrant and an administrative warrant. And that's complicated, right? And they exploit the fact that anyone who isn't a lawyer is highly unlikely to know the difference. So the point is that neither of these statutes can possibly apply to Judge Dugan because there was not a pending judicial warrant. There was not a pending proceeding of any kind. I have searched and I have found 0 cases holding that an ICE warrant counts as process for either 18 U.S.C. 1505 or 18 U.S.C. 1071. None. This is not a real arrest.
Yeah, and before we kind of wrap up, I want to talk about this from a policy perspective, because what you're seeing the president do here is roll back a lot of policies that were public policy decisions made by prior administrations, including Republican administrations, right? You wouldn't arrest people in hospitals or schools or courthouses because it was bad public policy to discourage immigrants from sending their children to school or testifying against their accusers or showing up as witnesses in state criminal cases and, or going to the hospital when they were sick or taking their kids to the hospital. All of these things. It was considered to be bad for society, bad for all of us to force immigrants into the shadows and out of public life, right? That it did not, it did not uphold law and order. What you're seeing here is a decision that it is more important to grab up immigrants and scare the shit out of people and make it clear that the government is the boss and can be in any space, right? State, home, federal, hospital, school, right? They are going into schools to interrogate children. And that's a decision that says it's more important for us to snatch bodies up so we can say we've deported millions of people than it is to ensure public safety. And that's a policy decision.
Yeah, I think you're exactly right.
Okay, that is going to do it for us today. Thank you so much for joining us. If you enjoy the show, we would certainly appreciate if you would give us a 5-star review and a nice comment on your podcast platform of choice. We will be back on Thursday with written content and on Friday with another show. Keep the faith. I know it's rough, but we're in this together. Thanks, guys.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Ipsa Media, LLC, all rights reserved.